Our next guest has argued over 50 cases before the U.S. Supreme Court, including the one we've been talking about all morning. Neil Katyal won a sweeping victory on Friday when the justices, in a 6-3 decision, rolled back many of President Trump's global tariffs. Katyal calls it a victory for the Constitution and for our founders' vision of America.
And the Georgetown law professor and former acting solicitor joins us now. Neil, thanks so much for being with us. You know, of course, everybody's going to try to interpret this. Some say, I've read some interpretations say, oh, you only have to look at the four corners of this particular case, and it's all that it applies to. Others are suggesting, like you have, and like I believe, that especially what Gorsuch said, and the majority, this is more general and sort of an admonition to the President of the United States. You need to read the Constitution. There are checks and balances, and if you want to do something, you got to use the United States Congress to get there.
Yeah, I certainly think that that's right. I mean, I think the decision speaks for itself, and it gave us everything, Joe, that we asked for. We asked for basically 6 things from the U.S. Supreme Court. We got each one not at the 90% or 80% level. We got it at the 100% level. And what we asked for, in essence, was just this, that our Constitution, when it comes to such a momentous decision over taxing the American people, it's not something that can be done by one man alone. And we don't care whether that person's name is Donald Trump or Joe Biden or whatever. That's a core constitutional principle, and that's what 6 of the 9 justices on the Supreme Court said. And you only need 5 in this game. We actually got 6, including 2 of Donald Trump's own appointees, as you say, Neil Gorsuch, but also Amy Coney Barrett.
Right, and who has, again, in many cases over the past few years, ruled in ways that some of the hardcore MAGA base may not like. I'm curious, and you may not want, because you argue in front of the court, you may not want to get into specifics. I will say, though, I have been disappointed by the direction that Justice Kavanaugh has taken over the past year, in particular since Donald Trump got back into office. It seemed after he first got appointed, he followed closely with Chief Justice John Roberts, but that seems to have changed dramatically, especially in September when he wrote that Americans could be stopped based on their skin color, based on their accent, based on where they worked. Have you been surprised by what's happened with Justice Kavanaugh's jurisprudence and where he was in this case?
I think it's a good question. I mean, we're a very data-driven practice, and so we look at, who votes with whom over time. And if you were to look at Justice Kavanaugh's record on the Court of Appeals, he voted with the Chief Justice more than almost any other pairing in existence in the federal courts. They were in lockstep all the time. And I think it is fair to say that once he went to the Supreme Court, he has deviated some. They still vote together a lot. I think it's 91% of the time last year. But it is something of a break. And in this case, you're absolutely right, Joe. It was a huge break. You had 6 justices really saying, look, this is a momentous decision. It can only be made by the Congress. The president can't do it because the president lacks that power under Article 2 of the Constitution. But Justice Kavanaugh disagreed and said, I think that Congress has given the president this power. So, yeah, absolutely, there's a difference here.
Tell us your biggest surprise from the opinion.
Honestly, I wasn't surprised. I told my clients, which are these brave small businesses that stood up when no one else wanted to, and they were, everyone else was afraid of retaliation and the like, and these folks said, we got to do the right thing. I told them when I took the case, I thought it would be 6-3 in exactly this lineup. So I wasn't surprised about that. I wasn't surprised about the rationale that Congress is in the driver's seat. If there was a surprise, it was that I always hold hope for the 9 justices to speak unanimously. I thought this was a good case in which they would do that, and they didn't. It was 6-3. Of course, it doesn't matter in the end because you only need 5. But it was, it was something I was hoping to see all 9 justices sign on to an opinion that said the president here has gone way beyond the constitutional lines.
Yeah, the issues were so straightforward that even a dumb country lawyer like me expected a 9-0 decision, or thought that justices on the court would be embarrassed to not follow along with what is basic reasoning.
Yeah, on the other side, though, if you go back, Joe, over American history, you find almost no examples of the Supreme Court striking down the president's core initiatives. It may have happened once or twice in history, but that's about it. So that's the odds we were facing, which is, case after case in which the president wins because the court wants to defer to the president. And here the Supreme Court said no matter what that tradition of deference is and all those statistics and numbers, here, Donald Trump, you went too far.
Neil, we've all learned not to overstate anything, any event that happens, whether it's in Congress, whether it comes from the White House, whether it comes from the Supreme Court. I do wonder, though, whether you believe that this may be a decision that perhaps 5, 10, 15 years from now, people will look back on and say, okay, that's the corrective. During his first year, Donald Trump did his best to push out and expand Article 2 powers as much as he could. This was the moment when the United States Supreme Court said, we're not going to let you do it. There are rules of the game. It's in the Constitution, and we're not going to let you exceed that limit. Just like they did with Biden when it came to student loans.
I do think that there's something to that. I think that the Supreme Court here is saying, look, going further than this, that our Constitution prevents you from doing that. So I read the decision is less about President Trump specifically, more about the presidency, less about the politics of the moment, more about the role of the Supreme Court, the cherished role of the Supreme Court in our constitutional system. And here we see the Supreme Court standing up to the president, despite a lot of invective that's been levied, and saying, nope, we 6 of the 9 of us say you've gone way too far.
In reaction to the ruling, you have one governor demanding refunds for families across his state. Obviously, there's small businesses that were impacted here by these tariffs. Does the ruling, in the way you read it, indicate refunds?
So we didn't specifically ask for refunds. That's because our legal team researched this and saw, as a matter of course, if we win the case, we do think refunds will come back. And we are today launching a task force to fight for those refunds. We absolutely will fight tooth and nail for them if the federal government tries to hold that money back. They're saying already that they are going to try and keep this money from the Americans who paid for these tariffs. And we think that's unconstitutional and wrong. And there's a law passed by the Congress that allows for refunds. And we are going to go into court and get these refunds for all Americans who paid these tariffs.
Not to stay on Justice Kavanaugh too long, but many people, including myself, were struck by him saying, okay, even if these are illegal, it would just be too difficult for us to unwind them. Of course, it would have been much easier to unwind them if the court had ruled much earlier on something where the law was so clear. I'm curious what your thought is and what your argument is against that legal reasoning that we need to keep things that are illegal in place because it would be too hard to undo them when, of course, we all knew they were illegal from the moment they were put in place.
Yeah, that's not really a thing, Joe. There's no constitutional rule that says it's. Yeah, so I didn't think that argument was his most persuasive by any stretch. I think that he does highlight one important thing. When we won the case, I argued the case in the Court of Appeals, and we won it 7-4. And a lot of people were saying, go enforce this right away. Strike these tariffs down right now. Go on emergency motion to the Supreme Court. That's called the shadow docket. We studied it. We said we're not going to do that. We're not going to put the court in an emergency position because statistically, when you do that, you lose. The President Trump has won something like 22 out of the last 24 emergency motions before the United States Supreme Court. So instead, we slowed it down and said, we're going to give the court time to consider these issues. And we firmly believe if the court has the time, they're going to rule for us. And that's exactly what happened. But that's why, even though these tariffs were declared illegal back in the summer, Americans, unfortunately, still had to keep paying them. But here's what Donald Trump's Justice Department said. They said, don't worry, because if the challengers win, if we win, we'll give you the money back. They promised refunds. And so we are fighting for the promise that they made in a representation to the United States courts.
Neil, we want to see if you had thoughts on what could happen next. The president obviously registered a lot of unhappiness about this decision and 6 justices in particular. He's also said he's going to offer global tariffs, 10%. Then he quickly changed it to 15. They're trying to pull different levers and mechanisms, licenses he's talking about today, fees. What is your sense in these early hours? What is your sense as to whether this would stand up in court? Does the president have constitutional authority to deploy the measures he is now talking about?
Well, the measures shift every few minutes, so I can't really, speak to them all. But the main one that he's been talking about is Section 122 of the 1974 Trade Act, which allows for a 15% tariff for 150 days only. Of course, his whole program and what he said was necessary, otherwise America would be destroyed, is his sweeping of tariff authority, which went to 145% and was indefinite. So the Congress has passed that statute. Again, here's the problem for Donald Trump. His Justice Department, in our case, filed briefs to the United States Supreme Court and the Court of Appeals that said Section 122 is inapplicable and the president can't use it. So now he's turned around 100%. I'm not sure what his rationale could be to turn around, and he's going to have to somehow argue against his own Justice Department's interpretation of the statute. I think that's tough. I think it'll be, something that'll be fought about in the courts. But regardless, that's a much more limited tariff scheme than what Trump had tried to do, the president had tried to do earlier.
Georgetown law professor and former acting Solicitor General Neil Katyal, thank you very much for coming on the show this morning.